Hey everyone, welcome back to Love Soul Sanjay, the channel where legal thinking meets deep psychology and smart business strategy. Today's topic is going to blow your mind and possibly save you thousands of dollars. We are talking about how to use legal psychology to win business disputes. That means whether you are chasing unpaid invoices, dealing with a stubborn vendor, or facing an actual legal claim. This video will teach you how to control the narrative using tactics that are backed by both law and science. You're going to learn the same psychological method used by elite negotiators, legal consultants, and expert litigators, but explained in plain business terms. Stick with me because I will walk you through real scenarios, the biases you can use to your advantage, and even exact phrases to include in your emails and contracts. This is not theory, this is battle tested. Let's go. Moving forward with first one, legal psychology, what it really is. Let's unpack the term legal psychology first, because the truth is, most business owners have never even heard of it. Legal psychology is study of how human behavior, perception, emotion, and cognitive bias intersect with legal processes. In plain English, it means using psychological insight to win legal battles without going to war. Think about this. Judges are human, arbitrators are human, meditators, juries, and even your opposing counsel, they all come with built-in biases and mental shortcuts. So if you understand how people make decisions under pressure, especially in legal settings, you gain a strategic edge. This includes how people respond to language and framing, how authority bias works in written statements, why people trust visual data more than words, and how subtle cues can tip the balance in your favor. Legal psychology isn't manipulation, it's simply maximizing influence in a system that's already emotional, already uncertain, and trust me, in high stakes dispute certainly wins. Moving forward with next one, understanding the legal battlefield. Before you walk into a dispute, you have to know the terrain. Imagine showing up to a chess match but not knowing how a rook moves. That's how most people approach businesses disputes. In the US, disputes generally fall under first one, contract law, like of agreements, breaches, and terms. Next one, tort law, like of negligence, misrepresentation, fraud. Next one, administrative paths, like of arbitration, mediation, and small claims, and sometimes federal civil procedures. Now here is where psychology enters the battlefield. Let's say you include a mandatory mediation clause in your client contract. That's not just a legal mechanism, it's a psychological tactic. It signals two things. First one, you are prepared. Second, you expect resolution before conflict escalates. This flips the power dynamic. Now the other party knows they cannot just stall or bully their way out. They are in a game where you set the rules. So tip here would be like of always include choice of forum and timing triggers in your contracts. It reduces ambiguity, and ambiguity is the fuel of dispute. Moving forward with next one, psychological tactics that actually work. Let's talk tactics because psychology isn't magic, it's mechanics. Here are 5 powerful psychological tools that can turn even a weak legal position into a winning narrative. First one, anchoring bias. When negotiating settlements, start high. Why? Because human brains compare, not calculator. If you claim $10,000 in damages, even if you are willing to settle for a $5,000, You have set the psychological anchor. The other party's brain is now stuck, negotiating downward from your number, not upward from theirs. Use phrases like, based on precedent and standard hourly rates, our estimate of damages exceeds $10,400. Second one, mirroring and language echo. Use their words literally. If they say we are committed to transparency, reply with, I appreciate your commitment to transparency, which is why we are requesting these documents for resolution. This creates subconscious rapport, and people are less likely to fight with someone who sounds like them. Next one, framing. Instead of, you didn't pay me, say, this is breach of mutual trust and fair compensation that triggers reputational awareness, which many people care about even more than money. Next one, Zeigarnik effect. This one is weird. People remember incomplete tasks more than completed ones. Mention ongoing legal issues briefly, but consistently. Keep it front of mind. The more unresolved it feels, the more urgency it creates. Fifth one, social proof. Show them this isn't your first rodeo. Cite other resolved cases. Mention trends. Similar agencies have settled disputes like this within 14 days using structured mediation. Now you are not fighting them. You are just following what's proven to work. Moving forward with next one. Psychology in contract formation. Winning a dispute starts long before a dispute happens. It starts in your contracts. Here is how embedded psychologically directly into your agreements. First one, pre-commitment design. Use step-by-step checkboxes or phase sign-offs in digital contracts. Every time a client checks a box that says, I understand the terms, they are psychologically binding themselves to future compliance. Second one, default risk clauses. Instead of threatening a lawsuit, say, late payment triggers a 1.5% monthly interest as per Section 4. It's not hostile, it's just the rule. That removes the emotional friction. Third one, positive framing. Use phrases like a trusted agreement, transparent expectations, or professional collaboration. Psychologically, this creates moral framing. Breaking the contract doesn't just violate terms, it violates trust. And if a dispute arises, these phrases become part of your narrative. You are not the one suing, you are the one protecting the trust that was broken. Big difference. Moving forward with next one, courtroom and arbitration psychology. Let's go deeper. If the dispute reaches arbitration, mediation, or even a court, this is your psychological war zone. First one, first impressions. Mediators and judges form gut feelings in under 3 minutes. Dress smart, speak calm, lead with facts, not emotions. Second one, halo effect. Win one small point early, like a missed communication or failed response. That early credibility spills over into how they view your major claims. Third one, simplification. Reduce complexity. Use visual exhibits like timelines, receipts, charts. People trust what they can see. Keep your story linear. Judges are overloaded. Don't make them decode your pain. Fourth one, verbal delivery. According to Yale research, slower tempo plus downward inflection is equal to credibility. Don't speak fast. Speak like someone who is right and doesn't need to rush. Remember, logic gets you in the room. Emotion wins the ruling. Moving forward with next one, preemptive triggers to avoid disputes. Don't wait for legal mess. Use preemptive psychology in your daily business behavior, like of language cues in email. Use words like per our agreement and to maintain clarity. These aren't threats, they are reminders of mutual structure. Next one, scarcity principle. Set clear deadlines. People act when they feel like inaction has a cost. Next one, soft legal warnings. Use this phrase. We believe in resolving matters in line with industry practices and previous case expectations. That frames your demand as normal, not combative. Small cues like these help you win the battle before it even begins. Moving forward with next one, real case studies. Psychology wins. Let's look at two real world stories where legal psychology made all the difference. Case 1, freelance consultant versus startup. Unpaid for 3 months. Instead of aggressive emails, she sent a timeline with invoices plus a statement like of this documentation reflects our ongoing trust and we would like to resolve without invoking escalation pathways. Result, they paid 85% of dues in 1 week. Case 2, small retailer versus supplier. Used angling by stating potential damages at $22,000, even though the loss was of $11,000. Then cited three legal precedents in mediation. The supplier panicked about court cost, settled for $10,500 cash plus future discount clause. The law didn't change, but the psychological position did. Moving forward with next one, your business action plan. If you want to win disputes, avoid lawsuits, and protect your reputation, use legal psychology like a sword and shield. There is your checklist. In contracts, build psychological binding plus protection. In negotiation, use framing, anchoring, and bias triggers. In escalation, master first impressions, simplicity, and social proof. In behavior, email cues, language framing, and professional tone. And if all else fails, remember, even the strongest legal argument can collapse if it doesn't make psychological sense to the decision maker. Thanks for watching. If you found this valuable, don't just like, subscribe for more high level legal and psychological strategy content. I will see you in the next one.